all of our fellow colleagues and to all of the staff members of the legislature. Madam Speaker, I want to thank you very much for allowing me to initially open up with the discussion on Bill number 195. And just for the information of our colleague, it's the originally introduced version. I want to just say this first and foremost, thank you very much to all of you for allowing me to be able to place this on the agenda. I know that there's going to be perhaps some lively discussion in regards to this legislation, but I think that I've shared to a great extent my perspective in regards to hopefully getting it through in its present form through this body. Madam Speaker, this is legislation that had previously been introduced in a prior legislature, and it's a model off of a template that has been utilized by over 25 states in enacting Born Alive Infant Protection Acts in their respective jurisdictions. And I highlight that primarily because these 25 jurisdictions have recognized that, in fact, the 2002 Born Alive Infant Protection Act does not reach into the respective state jurisdictions, with the exception of federally financed healthcare facilities as well as medical facilities or medical facilities that are receiving federal funds. So that's one of the reasons why most of these jurisdictions of the 25 that already have enacted Born Alive Infant Protection Acts, very similar in nature to this that we're discussing this morning, have enacted that. Just a couple items on that particular note. First and foremost, as a federal law, the 2002 Act, because I know that act was referenced during the course of the public hearing and highlighting that it's a federal statute and it would be applicable to Guam. But these are some of the information that I've been able to glean over the course of the last few weeks in terms of preparing for this overall presentation. As a federal law, the Federal Born Alive Infant Protection Act only applies in limited circumstances. For example, the federal provision would only extend to those hospital and employees operated by the federal government or which receive federal funding. It will not prohibit private or state-operated clinics and hospitals from denying care or medical attention to born alive infants. Second, states can enact versions of this similar provision that are more comprehensive and protective than the federal version, and we all know that. And then also, lastly, state versions of federal laws function as reinforcement mechanisms for their federal counterpart. Madam Speaker, I introduce this not only because obviously whenever you introduce legislation, you need to be able to support the concept, but I introduced it because of what the nature of this provision provides. It provides that should an abortion take place and an infant come out alive, then that infant should be recognized immediately as a human being. Not as part of the continuous process of the abortion action on the part of the physician. And just based on that premise, if that infant who comes out during the course of an abortion is alive and is recognized as a human being, there are only natural steps that have to take place in terms of making sure that that infant is given as much medical attention as possible so that he or she can be able to live their respective lives accordingly. Madam Speaker, I say this with acknowledgement that there was an example of a situation such as this a short while ago of an infant that apparently was going through, or the mother was going through an abortion process, and an infant came out alive. And to the benefit of the infant, that infant was given immediately the medical attention that he needed. And I'd like to read the story about that abortion survivor, because I think that this says a lot about the possibilities of protecting life once that infant is brought into this world. And this is about a story from a gentleman by the name of Carey, Mr. Carey, and his daughter Caitlin. His excerpt, and it's included in the committee report, it says, "Our daughter Caitlin survived a late-term abortion attempt by a young woman who ingested pills issued by an island women's clinic. Instead of inducing a spontaneous abortion as intended, the woman went into labor, and a friend had the presence of mind to drive her to GMH, where she delivered a live 3.5-pound preemie and subsequently abandoned her there. Through the good offices of the social worker as well as the religious leader, they took the child into their home at age of 34 days. After 3 court appearances over the next 8 months, she officially became his daughter. He and his wife in this case. The girl is a bona fide miracle child. Not only did Caitlin escape the welter of medical issues one might expect in a child who entered the world under such adverse conditions, she emerged as a beautiful island girl, healthy, athletic, and startlingly intelligent. Nothing, and he's referencing his wife, nothing Chris and I take genetic credit for, but we consider ourselves blessed for the privilege to raise such a child. And in this case, Madam Speaker, it goes on to highlight that Caitlin, at the age of 7, makes straight A's in the 2nd grade, and now she's relocated with her family to South Carolina, and she also successfully tested extremely well in her taekwondo and her karate classes. That's an example of what this legislation could do in terms of being able to save a life. Madam Speaker, if I can highlight some of the provisions contained in Bill 195-32 COR. Section 1 is the legislative findings and intent, acknowledging that this is legislation that was introduced in the prior legislature. Section 2 is the establishment of the Infant Child's Right to Life Act, which provides the title and then obviously all of the provisions. The first subsection is the legislative findings and purpose, and I wanted to highlight a particular section there where it reads, "It is the purpose of this act to ensure the protection and promotion of the health and well-being of all infants born in this territory. Therefore, this act mandates that healthcare providers give medically appropriate and reasonable life-saving and life-sustaining medical care and treatment to all born alive infants." It also, the next subsection are the definitions, and within the definition, subsection E defines the word infant for purposes of this act, and as used in this act means a child of the species Homo sapiens that has been completely expelled or extracted from his mother, regardless of the stage of gestational development until the age of 30 days post-birth. An infant is also a human being for purposes of Chapter 16 of Title 9, Guam Code Annotated. And if you're inquiring or you have questions about what Chapter 16 of Title 9 Guam Code Annotated references, it's the criminal homicide provision for our territory. The next subsection are the requirements and the responsibilities. Subsection D highlights the physician performing an abortion must take all medically appropriate and reasonable steps to preserve the life and health of an infant. If an abortion performed in a hospital results in a live birth, the physician attending the abortion shall provide immediate medical care to the infant, inform the mother of the live birth, and request transfer of the infant to a resident or on-duty or emergency care physician who shall provide medically appropriate and reasonable medical care and treatment to the infant. Subsection F on page 5 goes on to read, any infant, including one born in the course of an abortion procedure, shall be treated as a legal person under the laws of this territory with the same rights to medically appropriate care and treatment and birth and death. If death occurs, certificates shall be provided accordingly. The next subsection deals with criminal penalties, and I know, Madam Speaker, this is a section that was brought up during the course of the public hearing as a serious concern. And it reads, any physician, nurse, or other licensed healthcare provider who intentionally, with premeditation, or intentionally, or knowingly, or recklessly, or by criminal negligence, fails to provide reasonable and medically appropriate and reasonable care and treatment to an infant in the course of an abortion shall be guilty of a criminal homicide as defined in Chapter 16 of Title 9, Guam Code Annotated. Madam Speaker, I did highlight already the provision for Chapter 9, Guam Code Annotated. The next subsection deals with civil and administrative action, and then finally the construction. And this is where I think not only have all the jurisdictions within the 25 states that have enacted Born in Life Protection, Infant Protection Acts, have this particular clause which says and stipulates that nothing in this act shall be construed to affect existing federal territorial laws regarding abortion, and it also has other provisions in there. Madam Speaker, I certainly look forward to the nature of this discussion. I think that my position has been, because this is a similar template of what has been nationally through the 25 states been enacted into law but certainly making adjustments or making significant deviations from the provisions contained therein, I think you would not find me in support of doing that. And let me just close my opening statements, Madam Speaker, with all due respect to all of our colleagues, and we understand the nature of how principled we can be on certain issues. And I respect every single individual's position in here. And I look forward to the discussion. But to me, there was a heated discussion, not a heated, perhaps maybe an active discussion between myself and a senator in this room, and that individual knows exactly who that person is. But Madam Speaker, the question that was posed to me was, you're going to impose homicide criminal penalties for physicians in this particular case if an infant comes out alive. And my response during that conversation was, yes, the provision provides for it, but my perspective is, and will be during the course of this discussion, and has been for my life, my entire life, is that if that infant comes out alive, that infant is a human being, Madam Speaker. And that infant should be cared for and tended to like any other human being in terms of the responsibilities of this community and this territory, and that is to protect, do everything they possibly can. The physicians or the assistants or whoever is around that particular infant, do whatever he or she can possibly do to protect and to preserve that life. And I think that is really the underlying concept behind this particular measure. Thank you very much, Madam Speaker.